Good morning, everyone. It's a big honor to be here before you today. Ang totoo po ay nagagalak ako at madami kayong nandito ngayon dahil ibig sabihin, madami tayo na gustong magtulong-tulungan para magkaroon ng kultura ng privacy sa ating bansa. So now I will be talking about the rights of data subjects. Sino ba ang data subjects? When you look at the Data Privacy Act, you will see the data subjects mentioned a lot of times. And who are the data subjects? The data subjects are you, it's me, it's everyone whose personal data is being processed, collected, and used. So what are our rights as data subjects? Okay, these rights are provided in the Data Privacy Act and in the implementing rules. The implementing rules and regulations further explains what these rights are. So, what are these rights? Right to be informed, right to object, right to access, right to rectification, right to erasure or blocking, right to damages, right to data portability, and all these rights you can enforce by knowing that you have a right to file a complaint before the National Privacy Commission. So ano po ba ang mga ibig sabihin ng mga karapatan na yan? So when we talk about the right to be informed, it means you or we as data subjects have a right to information. First, the information that our personal data is being processed. We need to know that it shall, it is, or it has been processed. That's a basic right under the Data Privacy Act. We have the right that before the entry of the personal data into the processing system of any personal information controllers to be notified of certain information. So we have a right to know the description of the personal data, the purpose for the processing, the basis of processing, the scope and method of processing, the recipients and classes of to whom those data will be disclosed, the identity and contact details of the personal data controller, the retention period, and the existence of our rights as data subject, including the right to complain. So, what does it mean? It's the who, what, how long, for whom data will be disclosed. Now, what does it mean in practical terms for government agencies? It means that you have to be ready to provide this information to the data subject. This can be in the form of a privacy notice, which will be included in your website, or this can be information that you directly provide when requested by the data subject. If you notice some applications, for example, they would constantly tell you when there is an update of their privacy terms. It's the same with government agencies who use and collect information. Whenever there's a change in the way that you're collecting, using, or disclosing the personal data of Filipinos, then you have to inform the data subjects. You have to inform us of what processing you're doing with the data. Okay. And the data subject also has the right to object. So what does the right to object mean? It means that if there's a change in your policy, or if there's a change in the way that you intend to use the personal data of citizens, then the data subject has a right to refuse or to limit the processing that you're doing. So what does this mean? For example, if you have been collecting the personal data of a citizen, of a data subject, for one purpose, like for providing benefits, and then you decide that you want to share that data with another government agency, the data subject has to be notified of that fact, and if the data subject refuses, then you have to honor the rights of the data subject. That is the essence of the right to object. So there are exceptions. In general, the data subject should know this, how you are processing his or her personal data, to what extent, what kinds of data you're using. But there are instances when you don't have to inform the data subject of the processing. So these are the exceptions. For example, when personal data is needed pursuant to a subpoena, when the processing are for obvious purposes, like if it is pursuant to a contract between the personal information controller and the data subject. So when you're processing the employment records of an individual, then that you don't have to notify the individual of such fact. Okay, or if the information is being processed as a result of a legal obligation. So for example, are there any like a local hospital, for example, you're processing the records of your patient, and then someone calls for that records to a subpoena. You don't have to inform the patient that his or her medical records is being given to a government authority because of a subpoena. Okay. In terms of, let's say, PhilHealth benefits, the patient or our citizen or the data subject has a contract in effect with PhilHealth. So when PhilHealth is processing the information pertaining to the patient as a result of that contract, like giving of claims, then you don't have to inform the patient that we're processing your data to process the claims that is being claimed under this contract. Okay, and of course, as a result of a legal obligation, for instance, when the Department of Health collects information from hospitals for purposes of reporting communicable diseases, this is pursuant to a law, a legal obligation. They don't have to inform the patient that they're doing such thing. So for your agencies, you have to be aware and familiar of your mandate, which can be found under the Revised Administrative Code or your other laws that govern your organizations, to know which processing of personal data are your legal obligations. So if these are your legal obligations, you don't have to notify the data subject of the processing in relation only to that either disclosure or that processing. So the data subject has a right to access upon demand. Now, what's the difference between the right to information and the right to access? Right to information is that general right that data subject can invoke to say that he or she has to be given that information. So this is usually practiced in the form of a general notice, the right to information. But the right to access, this is one of the most common rights that is being invoked by data subjects in other jurisdictions. So you will expect that in the next few months, once the data subjects or we know of this right, then your agencies may also be asked for information and for access to information. This is, of course, different to the freedom of information. This is access to information about the data subject. Now, they can demand, and you have to give in to the demand unless there is justification for not giving in to the demand for access. And what does the data subject, what can the data subject demand? The data subject can demand for the following: personal data that were processed, the general, what are the contents of my data with you. So all my personal data that you are processing, I want to know what those are. The data subject can make a demand in the form of an access request to you under the Data Privacy Act. The sources of personal data. So there are instances when a government agency may actually be getting his or her personal data, its personal data from another government agency. For example, the local government might actually be getting government data from the SWD, or you might actually be getting the data from telco companies. From whatever sources of data, personal data, the data subject has a right to know where the data about him or her came from. Okay? Names and addresses of recipients, to whom did you give the data? So even if it's pursuant to a legal obligation, for example, you reported the patient's personal data to DOH pursuant to a law, and the data subject makes an access request, then you have to tell him who received his or her information, the manner and method of processing, the reasons for the disclosure, whether it's pursuant to law, whether it's pursuant to a subpoena, information about automated processes, particularly when those processes are made to make a decision about the data subject. So right now, if you are processing information and you are making automated decisions, meaning no human input, I think in the private sector, this will be much more common. Like, for example, whether if your loan application is being rejected or denied or approved based on automated processes without human input, then that's an automated process that involves a decision that will affect the data subject. So those information, the data subject has to know. And when the data subject demands access, then you have to give the data subject that information. Okay, date when the personal data were last accessed and modified, and the designation, name, or identity and address of the personal information controller or representative. So ito po yung siguro in practical terms, medyo magiging mahirap, especially if your record system are not yet fixed, because maybe the data of one person are in different departments or lost or stored somewhere. So if the data subject makes a request, baka po mabigla kayo kasi hindi ready yung agency nyo na ibigay ito. Sa ibang bansa, ang ginagawa nila, like sa mga social benefits, may SSS ba dito? They will request access to information to know how updated their records are. So, ito po yung, we know, one of the biggest percentage of requests that an agency will get, an access request from a data subject. So, if you are not prepared to do this now, then now is the time to start. Okay? Okay. Right to rectification, it means the right to dispute the inaccuracy or error in your records. So, if there is something wrong with the records of the data subject, then the data subject can request for correction. And the data subject has to receive the new and retracted information, and recipients previously given the personal data must be informed of the inaccuracy or rectification upon reasonable request of the data subject. Now this one, the right to erasure or blocking. If the most common request is the right to access of information, this right of the data subject, which is provided in the Data Privacy Act, will perhaps be the most difficult to comply with. And if you're using IT systems, you might have to develop a new approach to be able to do this. Because the right to erasure or blocking means that the data subject can request that his or her personal data in your systems, or in your filing systems, or in your records be removed or erased. For many, this is difficult. But as long as it's any one of these grounds, the data subject can request for erasure or blocking. Okay? If the data is incomplete, outdated, false, or unlawfully obtained, if it's being used for unauthorized purposes, if it's no longer necessary for the purposes for collection, if the private information is prejudicial to the data subject unless justified by other freedoms, and if the data subject withdraws consent or objects to the processing and there is no other legal ground or overriding legitimate interest for the processing, if the processing has become unlawful, and if the personal information controller or personal information processor violated the rights of the data subject. So this means that if the data subject feels that his or her rights has been violated, or that the processing is no longer necessary, then the data subject can actually request that his records be erased. For government agencies, I don't think that this will be commonly used, but this will be more for private entities wherein they want to be able to remove their data from, like for example, if they're part of a commercial, they're customers of a commercial entity and they want their records to be removed. Or in the case of, there was a case in Canada wherein there was a website, where you sign up for certain benefits which will allow you to date, and then they can request that their data be removed. Now, if you've heard of this case in Canada, and involved other jurisdictions as well. The data was not removed. So when there was a hack, when that website was hacked, a lot of people who wanted their names removed from the website were exposed. So it became a big problem. Now, this right is also available to our data subjects under the Data Privacy Act. Okay. And the right to damages. This means that if a data subject has been injured or his rights has been violated that results to an injury, then the National Privacy Commission can award indemnity or damages to that data subject. So all the other rights, actually, including the right to data portability, will be enforced by the data subject. And if you refuse to grant these rights to the data subject can always file a complaint with the National Privacy Commission. So what is the right to data portability? The right to data portability is probably one of the first in the world that was put into law. It was just recently introduced in the GDPR of Europe, but it has been in our law since 2012. So what does it mean? It's the right to obtain from the controller a copy of the data undergoing processing in an electronic or structured format. This essentially means that a data subject should be able to transfer his or her records being processed in one agency to another. So again, for government, I think a data subject will not be able to, or will have no need to transfer their records from your agency to another government agency because of the functions. But the way it applies is usually, for example, you're subscribed to one telco, and you want to transfer all your accounts and all your records to another, then they should provide you with a copy in a format that can be readily used and transferred. So we have yet to see this come into operation, but know that this is one of the rights, again, that the data subject has in our jurisdiction. So in case someone asks for a copy from your government agencies of their records in an electronic format that can be readily used, it's either you don't have it because you're not using an IT system that allows for this, or it will be something like a right to access request where you will provide him an information. But the data portability essentially refers to that structure which they can use. So I'm still thinking of what need they will have of this from you, because essentially I don't think they will transfer PhilHealth to another PhilHealth record. I mean, another healthcare insurance provider, because essentially government agencies provide a service. So right to file a complaint. So even you, as data subjects, if you feel that your rights are violated, not by other government agencies, but even by private companies, then you have the right to file. If any of those, right to information, right to access, right to object, right to correction, if any of those rights are violated, you can always go to the National Privacy Commission. And as government agencies, you have an obligation to inform all data subjects that if their rights are violated, that if you, as government agencies, violate their rights, then they can go to the National Privacy Commission to complain. Another note, our law is also unique in the sense that it provides for the transmissibility of rights. If someone dies, the lawful heirs of that person can continue to invoke the rights of the data subject. So this one is perhaps an important slide for government agencies. When can you refuse, or when can you say no to the data subject? So these rights, if the personal data are used only for the needs of scientific and statistical research, and on the basis of such, no activities are carried out and no decisions are taken regarding the data subject, and if the processing is for the purpose of investigations relative to any criminal, administrative, or tax liabilities of a data subject. So they cannot request to be notified, for example, that you are processing their data in relation to an investigation. they cannot request for data portability when you're looking into them for a possible tax violation. But remember that the limitations of rights shall only be to the minimum extent necessary to achieve the purpose of the research or investigation. It means it has to be specific to that purpose. So if you're investigating and the investigation is done, it means that the data subject can now avail of all his rights. Okay? The limitation is by way of exception. So the general rule is that the data subjects, the data subjects, will always have these rights. In certain instances, when it might be detrimental or it might sacrifice an ongoing investigation, or it's only for the purpose of scientific and statistical research, then some of these rights may not be available to the data subject, but it will be decided always on a case-to-case basis because it's only an exception. So the following are the rights of the data subject: the right to information. The data subject will always have a right to know that his or her information is being processed, shall be processed, or has been processed. That's a basic right. Ibig sabihin, hindi pwedeng mag-process ng information ng kahit sino ng patago. Okay? Right to object. The data subject will have a right to limit the way his or her information is processed. If the data subject does not want the direction you're going or the intended use or any change in the processing, then the data subject can object. And if you refuse, the data subject can always complain to the National Privacy Commission, and the National Privacy Commission will look into whether your refusal is justified or not. Right to access in the form of an access request, right to rectification, right to erasure or blocking, right to damages in case the data subject suffers an injury, right to data portability, and again, all these, the right to file a complaint. The rights of data subject are at the core of the Data Privacy Act because essentially, this is what the Data Privacy Act intends to do. While everyone probably knows the Data Privacy Act as something that will help industries protect personal data, at the heart of it all is the need to protect the rights of data subjects. And the data subjects are us. In fact, the Data Privacy Act itself mandates that in interpreting the whole law, you should always be mindful of the rights of the data subject. So I think that's it. Thank you.